Court of Appeals Division 1 is now in session.
Please be seated. We're hearing a case today, Ridgell versus the Arizona Department of Child Safety. It's 1CACB 20-0069. Each side will have 20 minutes to do the argument. Apparently, you may reserve as much time as you want for rebuttal, but you'll have to keep track of the time yourself. The clock is in the middle podium, so although you're going to argue from the table, you're welcome to walk around to see the clock and accordingly. And counsel, if you wish to remove your masks for the event, you're welcome to do so. We are recording the argument, so when it's your turn, please identify yourself and your client so that we can keep everything straight when we review the video, and the argument will show up on YouTube in a day or two. We've read the briefs, we've conferenced the case, so we're familiar with the facts and the law. So when you begin your argument, just launch right in to what you want to talk with us about. Counsel, you may begin.
Good morning, Your Honors. May it please the Court, my name is Julie Gunnigal. On behalf of the appellant, Ms. Lindsay Ridgell, I will be reserving 3 minutes for rebuttal, if you please. Your Honors, this is a case about a mother and a medical marijuana patient who followed the advice and the authorization of her certifying physician and now finds herself on the child neglect registry for the next 25 years as a result.
Counsel, a question I have about all of this is that Ms. Ridgell visited Dr. Muhammad and got her card renewed, so the doctor certified that she could use marijuana pursuant to the MMA. That the act of certification does not seem to be the same as prescribing. And that, at least in my thinking in resolving this case, there's a critical issue.
So to address Your Honor's concerns, first, with respect to the idea of prescribing, Your Honor is correct. There can be no prescription for medical marijuana in this state or any other. Because cannabis remains scheduled at the federal level, doctors are not able to even use the term prescribe. It was one of the failures of the original Arizona Medical Marijuana Act. And that's why, Your Honor, we speak instead about a medication that's being administered and a certifying physician that certifies that there will be a palliative effect for that particular patient. Now, nothing in AMA said anything other than that pregnant patients could access this, provided that their qualifying physician said that they would receive that palliative benefit. Moreover, when someone becomes a certified patient under AMA, just because she becomes pregnant doesn't mean that those ailments for which she had the certification go away. And in fact, that was the case here. Ms. Ridgell was one of the original cardholders under AMA for the past 10 years and also experienced hyperemesis gravidarum during her pregnancy, which is that extreme form of nausea, for which she sought, again, the use of medical cannabis when all of her prescriptions failed her.
Well, and counsel, to follow up on that point, I realize there are several issues here. I wouldn't have a problem with saying that she is a qualified patient because she, was certified. My concern, and pursuant to that certification, she can use medical marijuana to treat the extreme nausea. But that's a separate, that can be viewed as a separate act apart from exposing your infant prenatally to marijuana. So while you can use marijuana to treat your symptoms, what you can't do is expose your infant. And I realize that in this instance it may be a factual impossibility to do one without the other, but isn't that how the statute, isn't that how the interplay between AMA and the neglect statute work?
I mean, respectfully, no, Your Honor. When the voters approved the Arizona Medical Marijuana Act, they forever changed what child neglect looks like in the context of cannabis use. And what the voters had to say about it, and to the extent that this court looks to the voter intent in terms of being able to interpret the act, the voters were clear that a person cannot be subject to arrest, prosecution, or penalty in any manner or denial of any right or privilege. That moreover, any use that's certified use is presumed to be a medical use, and in this case there was no indication otherwise. And that moreover, there is no more presumption of neglect. And when voters spoke to that, they spoke specifically to the presumption that the Department of Child Safety is accessing here.
But to follow the construct that I'm presenting, I presume that you would disagree with that. But if we're talking about we're talking about two separate acts, two different things. On the one hand, we're talking about use of marijuana to treat symptoms, which arguably, because she's a qualified patient, she can do that. But under the neglect statute, what she cannot do is expose her infant prenatally to marijuana. So are you saying that my construct is wrong, that it is only one act, it can't be two acts?
Well, first, a pregnant person and her fetus, no, Your Honor, are one existing human under Arizona law, at least until September 28th in the advent of 1457. But moreover, the voters, and the way that this should be interpreted is that the later in time statute, which is AMA, that altered the way that we view neglect under the law. And the voters spoke clearly to this, that there is no presumption of neglect or child endangerment for conduct that was authorized under this chapter.
Well, and how is there a presumption? Because the neglect statute defines neglect. It must be proved what the possible defense is, but I don't read that as a presumption, which would ameliorate any conflict between the anti-discrimination statute and the neglect statute.
Well, there's at least two problems with reading the statute in that particular way. First, the Court of Appeals Division 2, at least in dicta, has indicated that this is the presumption statute because it says that any exposure of a child in utero to a substance that's classified as criminal under Title 13 is presumably neglect without any other showing. AMA altered that and said that it needs to be an unreasonable danger to the safety of the minor and be shown by clear and convincing evidence.
What case was that under What case?
Oh, I'm sorry, Your Honor, it is referenced in our brief. Do pardon me for just one moment. That was Gerald M. versus Department of Child Safety. It was decided in 2016 in an unreported case 2CV-JV 2015-0130. And in referencing this statute as the presumption statute, what it does is it takes away that burden of proof that the Department of Child Safety would otherwise have to show when it comes to neglect. Because under that statute, it is presumed when you are exposed, neglect has occurred. And that is what the voters intended to remove. Moreover, Your Honor's interpretation is potentially problematic in that it reads out a portion of the voter-approved act. If this section is not the presumption that AMA refers to, there can be no other section under Arizona law that's viewed as a presumption. Within the whole of the child neglect law, there's quite literally only one reference to the word presumption, and it's with respect to the presumption of sanity when it comes to other kinds of cases. So this court should not be reading that that is not the presumption statute that the voters intended, because in so doing you would render inert an entire and very important voter-approved section of the Arizona Medical Marijuana Act. Moreover, it goes back to what the intent of the law should be as a whole, because the reason we are here is to protect children, at least that's the stated purpose of the Department of Child Safety. Yet there was no finding that Ms. Ridgell's conduct harmed her child. And in fact, when it comes to looking at the critical analysis under the science, what the department has done has relied on presumptions related to controlled substance use, and has relied on, as you can see from the amicus brief, some pretty bad and old studies. Ms. Ridgell, in fact, was the only person who put forward any science, and she was the only person who put forward any of the medical evidence. The Department of Child Safety did not even ask her doctors what was done during these consultations, whether it was with her qualifying physician or with any other physician, and as such merely made the finding that there was some sort of neglect here. Now that's exactly what the Arizona Medical Marijuana Act prohibits, because the Medical Marijuana Act says that all uses are presumed to be medicinal uses unless it is shown otherwise. There was no showing here. It also provides broad immunity for patients like Ms. Ridgell, that she cannot be the subject of arrest, prosecution, or penalty in any manner, or denial of any right or privilege.
Kayla, how do you square that with the other provisions of AMA that require warnings that that a mother may be subject to reporting when the doctor gives the patient the card? They have to acknowledge that they've been told that. It's on the card itself. It's, as I understand it, is at the dispensary as well. And as I read the record, Ms. Ridgell didn't tell any, and I realize that there's a dispute in the record between the ALJ's findings and the director's findings, but that she did not tell any of her doctors that she was currently using medical marijuana, and I understand that she told her OBGYN that she used medical marijuana before she was pregnant. So she's she's taking those, it appears she's taking those warnings to heart and not disclosing to the doctors whom she's seeing for her medical issues that she was currently taking medical marijuana. How do you square those warnings with your argument?
Sure. Well, I think there's two problems with that particular line of thinking. First, Your Honor has accurately stated what the qualifying physician is required to inform Ms. Ridgell of, that she may be reported. And it's important to note that the voters used the permissive may and not the shall. It's also important to note that the Arizona legislature viewed that may also as permissive, and in 2016, in fact, tried to alter the Arizona Medical Marijuana Act to prohibit pregnant people from being able to access marijuana, leading to the inevitable conclusion that the Arizona legislature reads AMA as allowing the consumption for some patients. And then, of course, there's the aspect of what is required to be charted, because to state it with perhaps a little bit more precision, it's that the doctors did not chart that Ms. Ridgell disclosed marijuana. And there is substantial factual dispute, and there was in the ALJ's courtroom as well, with respect to what was told to the doctor. But I would note that in this court, and in fact any other in the nation, one would be hard-pressed to find jurisprudence to say that a patient needs to look at her own chart and be aware of what that doctor is charting about her medical history in order to be free from unsubstantiated neglect charges. That is a problematic burden to place on a pregnant person, and it in fact undermines the intent of the statute. When we criminalize pregnant patients, what we say is that they are less than any other adult. And under Arizona law, all adults, including pregnant people, have the rights and abilities to chart their own course of medical care. And that's what AMA stands for as well, provided that that care does not provide, quote, a unreasonable danger to the safety of a minor as established by clear and convincing evidence. What Ms. Ridgell is asking this court to do is to ask the department to accurately apply the standards in AMA, which have not been applied in the director's decision, and should be, because they are applicable to her case. This is a case of first impression here in Arizona, but we also have substantial case law of AMA in other contexts. And what this court has found, and properly found in the court below, is first that AMA applies to this case. But secondarily, in applying AMA, what has been levied against Ms. Ridgell is in fact a penalty under the law. When this court considered the case of Ridgell, for example, who was a probationer who had an AMA card, what this court found is that revoking probation for the consumption of medical marijuana was indeed a penalty under the law. What Ms. Ridgell has been subjected to, not just the finding of neglect, but the placement upon the central neglect registry for the next 25 years, is in fact a penalty under the law. And that is explicitly what AMA does not allow. That no patient should be subject to an arrest, a prosecution, or a penalty in any manner. Secondarily, this court's analysis should begin and end with the interpretation of the Arizona Medical Marijuana Act, but even if your honors were inclined to go further into the interpretation of ARS 8-201, it needs, which is the statute that says that there is a presumption of any substance-exposed infant that has been neglected. There still is an additional portion of that presumption, which is that the exposure was not the result of medical treatment administered by a health professional. And in this case, that's exactly what the medical marijuana that Ms. Ridgell consumed was. It was a health treatment, a medical treatment that was administered by her certifying physician.
I'm confused by that because the doctor, I thought, pursuant to our earlier conversation, that the doctor certified that the patient can use marijuana pursuant to the statute. It seems like the patient administers the drug to him or herself, and it's not, because of the prescription issue that we discussed earlier, that doesn't seem to be the same thing to me.
Well, I mean, respectfully, Your Honor, the words that the legislature has chosen to use is the word administer and not prescribe, which I think is notable. Moreover, this is not unlike other forms of medication that are prescribed pro re nata, PRN, as needed. This is no different than a patient being able to access Tylenol, for example, where it is taken as needed because the patient knows his or her own body and the effects, the palliative effects of these drugs. It's no different than a drug for erectile dysfunction being prescribed where somebody knows when to use it, is a use as needed. And that's how medical marijuana is consumed throughout the entire state. It's not it is not a prescription, and it's not a prescription for good reason. And because that is a straw argument, because that is an infeasible barrier to pregnant patients being able to access medical care, and for all of the other reasons we've stated, we would respectfully ask your honors to overturn the holding of the court below and the finding that Ms. Ridgell has committed neglect. Thank you so much.
Good morning. May it please the court, I'm Tom Jose, and I represent the Department of Child Safety. The primary question that confronts us today is whether the Arizona Medical Marijuana Act immunized Ms. Ridgell's marijuana usage. It did not. The reason for this was that she used marijuana by her own admission for something other.
Rebecca, is that the real question, or is, I don't know that that's counsel's argument. I think counsel's arguing that a different standard should apply, whereas the department could show if she caused an unreasonable risk of harm and the department is able to prove that by clear and convincing evidence, then
that's under the
guilty, she would be responsible for neglect.
That would only be if the Arizona Medical Marijuana Act applies in the first place, which it does not. And the reason for that is
It doesn't apply at all.
No, it does not. The reason for that is Ms. Ridgell used marijuana for something other than her certified medical condition. So Dr. Muhammad certified Mother to use marijuana to treat slow gastric emptying. Mother has admitted to both using it for hyperemesis gravidarum and to help her sleep.
But counsel, the statute says symptoms as well, and extreme nausea is a symptom of all of those things, and it seems slicing it very, very thin to make that kind of distinction.
That might be, but she also admitted to DCS that she used it to help her sleep, which was not part of the nausea for her slow gastric emptying. It is not related to IBS, and it is not related to hyperemesis gravidarum.
Is it a stretch to say if you've got severe nausea that you can't sleep very good?
That may be true, but Mother has also indicated when she appealed from the PSRT decision, she indicated that her nausea was caused by her hyperemesis gravidarum and not her certified condition of the slow gastric emptying, which indicates that she seems to know the difference between the two kinds of nauseas and that she purposely used it for a non-certified condition.
I find that if I have extreme nausea, I'm not sure I can distinguish, oh, that's because of this condition and not the other condition. Mm-hmm. I have extreme nausea. I am permitted to take marijuana to treat my nausea. I don't really care what is causing it. I'm using the marijuana to treat my symptoms. And how can an ordinary person make that kind of distinction, and that should have some consequence?
Well, there seems to be a distinction both from what Dr. Muhammad wrote, because Mother knew that she had hyperemesis gravidarum at least as of November 2018. She saw Dr. Muhammad in December of 2018, and Dr. Muhammad then distinguished the nausea due to slow gastric emptying. She did not put nausea due to slow gastric emptying or hyperemesis gravidarum, which Mother was already diagnosed with at that time.
If we were to disagree with you on that distinction, then what?
Well, then, as you were referencing earlier, Your Honor, there is this kind of two-step thing that the Medical Marijuana Act permits patients to use marijuana to treat their symptoms, but it does not allow parents to expose children to marijuana. And there's a few reasons we can think this. First of all is just in the text of the statute itself. So you're not allowed to smoke marijuana in a public place or in public transportation, but you're also not allowed to even have marijuana on a school ground, which indicates a higher standard to prevent marijuana from getting exposed to kids. Second is the fact that children under the age of 18 are allowed to be qualified cardholders, but there is a higher standard both under the statute and the regs for children under 18 to be considered qualified cardholders. So the statute itself has these higher standards for children to be exposed to marijuana, even when used medicinally. So a parent is allowed to treat their condition for marijuana. They are not allowed to expose their children to it unless they meet those higher burdens under the statute. In addition to that, Ms. Ridgell has pointed to the Gerald M. case. That's the memo deck from Division 2. And that does seem to meet all the rules of Supreme Court Rule 111 as persuasive authority. However, I would like to point this Court's attention to Judge Howard's dissent in that case, particularly paragraphs 53 and 54, in which he says that parents are not allowed under the AMMA to allow the children to be contaminated with a narcotic drug through second-hand smoke. And so Judge Howard's point in his dissent there is that there is this distinction. There is an allowable usage, but that allowable usage does not extend to allowing children to be exposed to marijuana.
So, is your argument, as I was questioning Ms. Gernagel, that is not a presumption?
Well, we've briefed that it is not a presumption, it is merely just a statutory definition, that simply the legislature has just simply said neglect means anything in 133401 being exposed to a fetus. So as long as you meet the definition of neglect, that is neglect as the legislature has defined it.
But there's no once that's proved, once the exposure is proved, then that's it, correct?
Mm-hmm. Yes.
What do you mean that's it?
Well,
There's a presumption. There's a presumption that the baby was born with that chemical or with that drug, and that constitutes neglect, correct? And if the patient can show that it was administered, that treatment was administered for that drug by a doctor, then the presumption is rebutted.
Yeah, that likely is what...
I'm not asking you to, I'm not trying to convince you to agree with me, but I'm just throwing that out there. It seems like what DCS is, in my view, from reading the briefing, that DCS is taking the position that this is an irrebuttable presumption when it comes to medical marijuana and medical marijuana only, that all other prescriptions, again, I understand that marijuana cannot be a prescription, certification, but medical marijuana is clearly, according to the department, treated differently because it can't be prescribed. Is that correct?
Yeah, and there's...
And it can never be prescribed, nor can any treatment be administered, ever. So to me, it's a bright line rule, is what the DCS is advocating.
We would certainly say it can never be prescribed because obviously federally, and as Ms. Ridgell admits, it cannot be prescribed under the federal rules.
Could a doctor administer it?
Well,
without running afoul of certain things that the parties have pointed out in light of federal law?
It's unlikely, and this is actually where Ms. Ridgell says that marijuana is the same as any other pharmaceutical drug. This is where it kind of starts to break down. Because when you're prescribed a pharmaceutical by an MD, you then go to a pharmacist who is also statutorily defined as a health professional. And usually you would say the pharmacist administers that. That's the person you talk to about, oh, here's your dosage, take it with food, don't take it with this. And whereas with marijuana, you are certified by the doctor, and then you go to the dispensary, which is one of the definitions of administer from Merriam-Webster is to dispense, which I find interesting because medical marijuana patients go to a dispensary and are dispensed their marijuana by somebody who is not a health professional. They're done by a dispensary agent. And so a dispensary agent is not statutorily defined as a health professional. So as far as administered by a health professional, the person actually giving the marijuana to the patient is not the person who certified them to do it. It's somebody else who is not certified as a health professional under any part of ARS.
how is what happens here any different than a doctor who, and I'm just using the word for purposes of the question. I realize there's a dispute here. But if a doctor prescribes medication that is taken at the patient's discretion, how is that any different than what happens when a doctor certifies that that the patient may use marijuana?
Because usually in that circumstance, with a prescription, either the doctor or the pharmacist will talk to the patient about, here are the dosages, use 2 milligrams of X pill twice a day, once with breakfast and once at dinner. And that's not what happens under the Medical Marijuana Act.
The question, Judge Howe's question was, what if it just says as needed?
And if you take it as needed, thank you. Even taking it as needed, there is no discussion between the certifying physician and the patient of what are the different dosages, what are the different strains, what are the different routes of administration. So even if you're talking about something as banal as acetaminophen, there are certainly different dosages that you can get. You can either take it in pill form, a tablet, you can take it by liquid. There are different things, and your doctor can talk to you about that. Oh, here's something that may help you in that. Whereas with medical marijuana, that's something the patient is talking to the dispensary agent about. They're talking about the different strains. They're talking about different routes of administration, the different ways to actually use marijuana. Whether that's vaping or smoking or taking edible, that's something that the patient is talking about with a dispensary agent rather than with a health professional in the form of an MD or a pharmacist. So as far as who's actually administering it, it's not the certifying physician, and the person who is administering it is not a health professional under the Medical Marijuana Act, whereas even with other take-as-needed pills that you might get from a doctor, either the doctor or the pharmacist, each of them a health professional in their own right, is the one administering the treatment.
Counsel, was there any factual findings with regard to any of that? Any discovery that took place with whether or not she actually sought that type of information from her doctors, including from Dr. Muhammad?
There's no evidence of the record that that discussion ever happened between Ms. Ridgell and Dr. Muhammad, and the only other things that we have in the record are the medical records from the ER, the OBGYN, and the coordination of care document. And I'd like to point out that contrary to Ms. Ridgell's assertion, it was not simply that her chart showed that she simply omitted her marijuana usage. If you look at the coordination of care document from May 2019, it actually shows an active stop date of her medical marijuana usage in September of 2018. And that's going to be at IRA 39 at 7.
And that was her OBGYN?
That was, I am not entirely sure who Dr. Moore was. It's called a coordination of care document. But that shows affirmatively that it was reported to at least one doctor right before the child was born. The mother had not been using marijuana for the last 2 trimesters. So contrary to her assertion that it simply is omitted from these documents, there is a document that actively shows that there was misinformation about mother's marijuana usage that got to her doctors.
Let's presume that she did, just flip the facts and say that she told her that she just goes to that doctor and other doctors, that she just goes to all of her care professionals, that she was in fact using marijuana. Would that change the department's view here?
Well, it very well could.
How so?
Because that is something, first of all, as a statutory matter under 20125C, that changes the definition of whether it was administered by a health professional, because this is something where if mother is disclosing this to her MDs and they're then creating a treatment plan that includes marijuana as part of it.
But the word administered, does that mean, because that's, everybody keeps focusing on that. If administered is giving, the doctor's not giving, right? The doctor's not giving marijuana. The pharmacist, as you said, is not giving marijuana. It's a dispensary where she goes and picks that up. She's giving it to herself. So I still don't know how that moves the needle away from, I guess what I'm saying is that I view this as, the department's view is that this is really sort of a strict liability offense. That once the drug is found to be in the baby, that that's neglect per se.
It's not necessarily the way the department conducts its investigations.
Give me an example where it wouldn't be. I mean, I just don't understand how a physician can provide any administered treatment within the confines of his responsibilities under the his or her responsibilities under the AMMA and in compliance with federal law as it currently exists.
I think that it could be done, we've talked about some ways of, to manage or supervise the execution of, as a definition of administer. And so if the doctor is not necessarily saying, I recommend you take marijuana, but instead saying, I understand that you're taking marijuana, now let me supervise the execution of the rest of your care plan with that in mind so that we can coordinate everything else.
So that makes all the difference? I'm really confused because if marijuana cannot be prescribed or administered, then what if you tell... I think there is significance to Ms. Ridgell not telling, but I don't understand how that then would negate a subsequent finding of neglect. Because I still don't see how it would be administered or prescribed.
Well, and another thing that could happen is that you could get, for example, a coordination of care between an MD and, say, a naturopath like Dr. Muhammad. So you have somebody who is, the certified, the qualifying physician who's working in conjunction with the other health professionals, and the naturopath is saying, I'm only certified by the state and doesn't have those federal concerns, clearly is somebody who's certifying patients for medical marijuana. And if they coordinate, those two health professionals can coordinate together on the care plan.
So the coordination makes it administered or prescribed under the neglect statute? Is that what you said?
Well, there's no prescription under the neglect statute. It's a health plan, healthcare administered by a health professional. And health professional, in this context, under ARS, would include people other than MDs.
So this whole case would go away then if Ms. Ridgell's OBGYN consulted with Dr. Muhammad?
It certainly could have, and as far as things go, any case could go away if the facts are different, but they simply aren't the facts here,
If, I don't want to go too far afield here, but if I'm a medical malpractice carrier, insurance carrier here, I'm very concerned if my doctor is sort of in the middle here.
Mm-hmm.
Why, kind of, sort of giving advice, kind of, sort of giving treatment, but not really. I mean, this seems like a fuzzy line here to have somebody revoke, prohibit or penalize them for 25 years for the ability to have a job that has anything to do with children, the vulnerable society.
Mm-hmm.
And I think we need to really get to the bottom of this is when we walk out of this room, what is the bright line rule we're going to write down going forward?
Well, one thing that this court could look to is that the Statute 362813D does not apply to entries on the registry, and instead, by its own plain terms, applies only to custody, visitation, and parenting time. So if you look at 362813, there are 4 subsections of it. The first one concerns school enrollment and the lease of land. The second concerns hiring and employment. The third concerns medical care. And D, by its own terms in the first clause, concerns only custody, visitation, and parenting time. That subsection says nothing about who are we placing on the registry, on the central registry.
Counsel,
Go ahead.
how do you square that with the case law that from our Supreme Court that says this is supposed to be interpreted broadly, that those immunities are supposed to be interpreted broadly?
Well, if we look at the structure of 2813D, we have 3 clauses there. And the second clause, the one that starts with, "and there is no presumption," that is the only clause in that sentence that references conduct allowed under this chapter. So if you take that second clause out and you simply, this is the problem with Mr. Ridgell's construction of looking only at the second and third clauses. If you ignore the first clause for that purpose, it means you should also only apply the first and third clauses together, which would ignore conduct allowed under this chapter. It completely writes out conduct under the AMMA from that subsection. So all 3 subsections have to be read together so that you get conduct allowed under this chapter with the presumption, as well as the clear and convincing evidence standard, but that is only going to apply when there's custody, visitation, or parenting time, which was never an issue in this case.
Before, your time is short, before we let you sit down, I just want to clarify from my own understanding. It's the department's position that if a doctor consults with the certifying doctor, that somehow changes the definition of administer or not. In that kind of circumstance, then marijuana would be administered. Is that the department's position?
The department's stance is that it takes every case on its individual facts, and
But we have to create a rule, and if the department is taking the position that that marijuana in certain circumstances can be administered, then that really presents a whole different analysis.
I think our briefing has been consistent that there certainly are times where marijuana can be administered by a health professional. It's just that in this case, the record contains no evidence that any health professional, be it Dr. Muhammad, the ER doctors, or the OBGYN, ever actually administered marijuana to Ms. Ridgell.
I thought that violated federal law to administer, for a healthcare professional to administer marijuana.
Not necessarily, because health professional is defined by Arizona revised statutes without reference to federal law.
So we really don't have a rule. We don't have a bright line rule here then.
We may not. Like many things under medical marijuana, this is a little bit of a messy subject. But again, if you'll allow me to close, I would just point to the fact that our position is that Ms. Ridgell's marijuana usage was not covered by the AMMA, and if this court so holds, it would not have to reach the issue of either administration or 2813D. Furthermore, for those reasons, we think that the director did not make an error of law in his decision, and his factual findings are otherwise substantiated by substantial evidence in the record. Therefore, he did not abuse his discretion. The Superior Court was therefore correct in affirming that decision, and this court should also affirm the decision.
Thank you, Ken.
Thank you.
Thank you, Your Honors. I will be brief. Every Arizonan should be troubled at the position that the Department of Child Safety has taken in this courtroom today, that somehow the consultation between doctors is what the difference between neglect and not neglect is under the law. By saying that neglect is determined by the conduct of the doctors, you have taken the patient out of the equation. You have placed the power solely in the hands of the doctors, and it allows a situation where the patient may not even know what her doctors are consulting about, and it places her in an impossible situation where she has to police her own doctors in order to have access to what Arizona voters have defined as a medicine. If there is significance in the fact that it is not charted that Ms. Ridgell's doctors have coalesced around a standard of care, it is still the DCS's burden to show that there is a danger to the safety of the minor and to do so by clear and convincing evidence. And in this case, there were simply no findings that a child was harmed. Your Honors, when the voters spoke in the Arizona Medical Marijuana Act, they did so intentionally. They said that meconium in a diaper, that pee in a cup would no longer be the standard of neglect when it comes to marijuana, because you cannot tell how good a parent is going to be by how she urinates in a cup, whether she'll read to her children at night, whether she'll provide a loving home, whether she will be supportive in their teenage years. And instead said, if you're going to reach the determination of neglect, Department of Child Safety, you have to do so by clear and convincing evidence there has been a danger in this patient's use. Because the department did not establish that, did not properly apply the standard, Ms. Ridgell would ask Your Honors to overturn the decision below and the department's decision to place her on the Child Neglect Registry for the next 25 years. Thank you so much.
Thank you, counsel. We appreciate your arguments today and answering our questions. We'll take this matter under advisement and we'll issue a decision in due course. This court stands adjourned.